Yeah, so we would like to discuss health rights in Ghana, constitutional, statutory, jurisprudential, and the policy context. And uh, there are two local articles which do justice to this topic. The article by Professor Tukuba on the right to health in Ghana, healthcare, human rights, and politics, which is like a chapter in the edited book by Jose Zuniga and others with the title Advancing the Human Right to Health, published by Oxford University Press in 2013. And the former Attorney General, Honorable.
Hello, my lord.
Please, we can't see the screen again.
Honorable Benjamin Kunbour, he did an article titled, "Is there a right to health?" Hold on. If I want to see the screen, I'll show it. Okay, I'm introducing the topic. Yeah. So he did an article called "Is there a right to health in Ghana? The Case of Ghana's Constitution." It's an article published by the University of Cape Coast Law Journal. So what I do is that I make both articles available to you, and you read it. Your topic is considered as having been treated. Yeah, so that is how it is. And again, it's not anything for you to struggle with, because we'll be discussing the issues back and forth in the various presentations that you have been making. So Dr. Kunbour's article, I mean, it's very detailed, trying to explore how the right to health is recognized or treated by Ghanaian law from the point of view of the Constitution. And it's relatively recent, so I will encourage you to read it. It's not difficult to read. You enjoy it. You write very well. So first, a point will be made that we need to appreciate that health is very foundational. And this is beyond debate, because if we are talking about democracy, we are talking about any type of society. If human beings are not in existence, if human beings are not treated with dignity, and people are not allowed to participate, then they don't mean anything. And all these are very much dependent upon health. And that point is made effectively by Dr. Kunbour in his detailed reflection on the subject. So he begins his paper by making the observation that health is the most basic asset for improving the human condition, irrespective of socioeconomic status. And that is true. No wonder in one of our local languages or dialects, there's a saying translated literally as if you become miserable, or if someone will have an advantage over you, it's only when you are sick, right? The accounts will say that that is to say that the only thing which would hold you back is if you don't have health. And that is why we couldn't have agreed more with the author, Kunbour, in his observation that health is the most basic asset for improving the human condition, regardless of your socioeconomic standing. Whether you are rich or poor, you need health. Without it, nothing makes sense as far as human beings are concerned. So therefore, as we know, if you have a poor health, it will definitely undermine your ability to work, learn, participate in public life, and enjoy other rights. So, for example, if I was not well, I can't be running the class. If you are not well, you may not be able to come online or even follow, as it were. And that is why we often say in our parlance that health is wealth. Health is wealth. It's, health is probably a better form of wealth than even money itself, as it were. But then he also underscores a point that if you put on our constitutional lenses, our health raises difficult normative, no, theoretical, philosophical, and institutional questions, including the following issues. Should health be treated as a legal right, enforceable against the state, or merely as a policy aspiration, dependent upon political goodwill and economic capacity? Indeed, from our previous lectures, I remember our attempt to look at Hufeld, the Hufeld analysis of rights, and use that to actually evaluate the viability, the feasibility of framing health as a human right. And that resonates very well with the issue which the learned daughter is posing. Should health be treated as a legal right, enforceable against the state, or merely as a policy aspiration dependent upon goodwill and economic capacity? And I hope you appreciate the distinction based upon what we have discussed previously when we look at the Hufeld analysis. So therefore, if health is a right, what exactly does it entail? If health is a right, what does it entail? What does it entitle individuals to? And how should courts respond to claims that implicate public expenditure and policy priorities? So these are pertinent questions which arise as we attempt to frame health as a legal issue, as it were. And again, within our own country perspective, we have noted, and we are reiterating again, that the 1992 Constitution does not expressly guarantee the right to health. That is to say that if you look at the Constitution, maybe the right to health as explicitly articulated in the International Covenant on International Covenant on Constitution and Cultural Rights and other related human rights may not be deployed using the same language, as it were. That notwithstanding, we have repeated references to health in various areas of the Constitution. And that actually underlines the importance which the Constitution attach to health. And for that matter, the point is made that if you look at the legal framework in Ghana, it is not correct for anyone to say that our law categorically denies or refuses to recognize the right to health. That may not be a fair observation. Rather, what one observes or notices is what we call constitutional ambiguity. Constitutional ambiguity in the sense that if you look at the myriad of related constitutional provisions, it comes up. The framers actually mean to, for example, recognize rights in the sense that we have come to understand with respect to the explanations in the general comment, with respect to various analytical framework, including Hofeld and so on. But because it rather brings up the issue of constitutional ambiguity, it calls for a careful interpretation. So that is the basic point that he makes to set the tone for his discussion. So it is pertinent to note, as we have been told at the very beginning, that we can see health as a human right, but not meaning a right to be healthy. So that is also important. And that conceptual distinction is clearly explained by Benjamin Kunbour in his work. That the right to health is not the right to be healthy. And for obvious reason, it's a very rational argument because no state can guarantee freedom from illness or biological vulnerability. No state, not even the richest of countries, can guarantee that. And on that basis, the argument he canvasses is that the right to health is properly understood as a right to the enjoyment of highest attainable standard of physical and mental health. And of course, this is not any new knowledge, which the author is propounding, because as we notice, it is an existing formulation originating from the Constitution of the World Health Organization and later reflected in other international human rights law. But he appreciates the importance of formulating the right to health in the way that it has been done, as not being the right to be healthy, but the right to enjoyment of the highest attainable standard of physical and mental health, and so on. And he says that yes, it is good formulation for reasons including the fact that the way that is being formulated recognizes resource constraints by referring to what is attainable. The attainable, in the way that the British Constitution puts it, is in itself a recognition that it is a continuum, or it's like a sliding scale, as it were, and very much dependent upon resources you have available or affordability. It also includes mental health, which has historically been neglected. And that is the importance of framing it the way that it has been done. And thirdly, it moves beyond clinical care to encompass broader social and environmental conditions. Yeah, so we are not only talking about when you are sick and you have gone to hospital, you receive the best of care. That is not the only aspect of the right to health, as it were. But you having safe, clean, social and environmental conditions are also very much important. So he will remind us of the underlying determinants of health, as you know already. The fact that health is an inclusive right, and it includes not only access to healthcare services, but also what we call the underlying determinants of health, such as safe drinking water, sanitation, adequate nutrition and housing, healthy working environmental conditions, access to health information, education, gender equality, and non-discrimination. So all these are important contributors to what we call the right to health. And the author, the Kunbour, makes the point that if we look at our situation in Ghana, the underlying determinants idea is very important or critical, because here many health outcomes are dependent on, are less dependent on hospital access and more dependent on poverty, sanitation, environmental degradation, and inequality. So these are the key drivers of health outcomes in Ghana, rather than just access to hospital. So if you look at Professor Tukuba's article, he makes a similar point that you cannot divorce health from issues of development, governance, and political economy. That health is very much linked to issues of development, governance, and political economy. And of course, we can agree with him on that when we go back to what we have just said, the underlying determinants of health. They can all be linked to these thematic areas: development, governance, and political economy. So we know the state obligation with respect to respect, protect, and fulfill, as elaborated by the UN Committee on Social and Cultural Rights, in particular Article 14. So Dr. Kunbour adopts the same tripartite framework of state obligation. Obligation to respect that the state must not interfere with access to healthcare or impose discriminatory barriers. Obligation to protect that the state must regulate third parties, including private healthcare providers, employers, and pharmaceutical companies. Obligation to fulfill. A state must take positive steps, including making the necessary laws or legislation, making necessary budgetary allocation, policy implementation to realize health entitlements. So this framework is important or very useful in analyzing how our constitution and other statutory regime deal with health. Particularly so when we even consider the fact that we don't have even like a very explicit rights language regarding health. So let's look at the constitution. So he took a look at the constitution and attempted to find out how the constitution, even if not explicitly, indirectly reflects the things we are talking about as constituting the right to health. So first, he acknowledges the point that there's an absence of express right to health. That is to say that the Constitution does not explicitly enshrine a self-standing right to health in Chapter 5, which is the chapter on fundamental human rights and freedoms. Kunbour notes that due to this explicit sense, as it were, in at least some commentators or text writers or scholars to treat this omission as conclusive evidence that no such right, no right to health exists in our constitution. Now he strongly and rightly rejects this formalistic approach and say that it is a mistaken view to say that because in maybe Chapter 5, the fundamental human rights and freedom, you don't clearly see the right to health enshrined there. You just jump to the conclusion that then our constitution does not recognize the right to health. Now, constitutions generally, including our constitution, not speak only through explicit enumeration, expressly saying things, but they also speak through structure, values, and purpose. And on that basis, Kunbour can be understood to be saying that the Constitution adopts a clustered human rights architecture of three pillars. One, enumerated rights in Chapter 5. Two, right means like the rights which are trying there. You come and take them one after the other. Two, unenumerated rights under Article 33, Clause 5. And then 3, socio-economic commitments in Chapter 6, the directive principles of state policy. So, if you want to understand the right to health in Ghana, it must be analyzed within this broader framework. So that is a point being see how that works out. So let's start from the directive principle of state policy, for example. If you look at Article 34, Clause 2, which we have read before, somebody read the exact text for us. Article 34, Clause 2. Is far from you.
Hello, Article 34, Clause 2.
Yes. Yes.
The President shall report to Parliament at least once a year all the steps taken to ensure the realization of the policy objectives contained in this chapter, and in particular, the realization of basic human rights, a healthy economy, the right to work, the right to good health care, and the right to education.
Good. Yeah, so if you look at that provision 34(2) of the Constitution, it mandates the state to ensure access to adequate health care. And the president is supposed to report annually to Parliament on steps taken to realize the right to good health care. Maybe before we move on, from this responsibility, trust on the president by the Constitution, one can do a study. Maybe those of you who will be writing a special paper, okay, and take as a study that, okay, the Constitution says in Article 34(2) that every year, the State of the Nation address, the president is supposed to tell us steps taken to realize the right to good health. Okay, if they are going to take, let's say that the last 10 years, or maybe because we have this 4 years the presidential terms, you can probably even take the last 12 years. The last 12 years and collect all the State of the Nation address, as well as the budget statement of the government, and try to look for the portion or segments. I'm already giving somebody supervision for your paper. And look for the segment or the portion of the State of the Union of the Nation address and the budget relating to health. And then you extract or take them out and can begin to analyze them and see if there is a certain trend that can be discerned. And what trend emerges? Is it the case that, yes, we can see the states through these reports by the president of the day to be increasingly be doing more and more to realize the right to good health care. Yeah, so that study can be done, and then we'll see what happens. So Dr. Kunbour makes a point that the provision in Article 34 Clause 2 of the Constitution is very important, constitutionally speaking, because it constitutionalizes health as a governance priority, not as a discretionary policy choice. In other words, the fact that it is mandatory. We look at Article 34 clause 2. It says the president shall, and those who are lawyers, or if you remember the basic legal thing you were taught, when shall is used in an enactment, and an interpretation act, it is imperative. It is mandatory. It's not permissive. So it's not optional or discretionary. It is mandatory. So Kunbour makes the point that by making it mandatory for the president annually to be telling us the Congress steps are being taken to realize the right to good health, it is very good because it has made health become a governance priority, not a discretionary word, policy choice. Again, the way 34.2 is also framed imposes political accountability, even if judicial enforcement is contested. So if the argument is made that, yes, we know the human rights enshrined in Chapter 5 of the Constitution to be directly enforceable without any dispute or controversy. But when it comes to Chapter 6, which is the directive principle of state policy, we can disagree as to whether it is enforceable, whether it is justiciable or not. So Dr. Kunbour is saying that the fact that the president is required mandatorily to be reporting to Parliament about steps being taken to realize that right brings about political accountability. And that is good, so that even if one takes the view that you cannot go to court and seek to enforce Article 34.2 because you'll be told that, well, it's a directive principle of state policy, and ordinarily speaking, it's not justiciable. Even if that argument is, carries the day, we have still achieved something significant. And the political accountability is even more important because you go to Parliament, you have to tell representatives of the people what you have done to realize the right to good healthcare, as it were. And again, Article 34 clause 2 approach also reinforces the idea that health is a right-based objective, not mere charity, as it were. And as I have indicated, there have been back and forth debates regarding justiciability of the directive principles of state policy. For the sake of those who are not lawyers and who are from other backgrounds, medicine, pharmacy, nursing, health administration, and so on and so forth, let me make a comment on the issue about non-justiciability of directive principles of state policy before we move on. So if you take the Constitution, there's a chapter we call Chapter 6, and it's headed Directive Principles of State Policy. Now, if you read the Directive Principles of State Policy closely, you notice that they talk about political objectives of Ghana, economic objectives of Ghana, social objectives of Ghana, education objectives of Ghana, cultural objectives, international relations, and then duties of citizen. So these are the thematic areas embodied in what we call directive principles of state policy. Now, if you look at Article 33, which is the last provision under the Chapter 5, the Fundamental Human Rights and Freedoms, we are told that if anyone has violated or infringed your human rights, you can go to the High Court to seek enforcement or seek a redress for the violation. So that is quite explicit, and there's no debate about that. But then, if you come to Chapter 6, we don't have equivalent provision of Article 33, as I told you. And for that matter, a view used to be bandied about that the directive principle of state policy is not justiciable, meaning that we cannot go to court and let the court directly enforce it. So that, and of course, later on in the Lotto case and subsequent cases, another viewpoint came, and that seems to be like the predominant viewpoint that the directive principles of state policy can be enforced presumptively. That is, there is a presumption that it's enforceable, but that presumption is rebuttable, meaning that based upon the circumstances of the particular aspect of it, you want to enforce it. If you we look at the exactly what is involved, and we put it in the context of the entire Constitution, based upon the principle that the Constitution should be read as a whole, then the court will be in a position to determine whether there's maybe a corresponding provision anywhere in the Constitution with respect to that particular aspect of the directive principle of state policy, which you want to enforce. If the answer is in the affirmative, then the court will enforce it. If the answer is in the negative, the court may not enforce it. So that has been what we call the justiciability debate with respect to the directive principle of state policy. Now, the second category is fundamental rights with direct health implications. That if you go to Chapter 5 of the Constitution, which contains the fundamental human rights and freedoms, there are rights not explicitly articulating the right to health, right to healthcare. That notwithstanding, even in the absence of the explicit reference to health, we have several fundamental rights that have important significance for health. So we'll start with, let's say, Article 13. If you look at Article 13 of the Constitution, it talks about the right to life. The right to life cannot be reduced to protection against arbitrary killing. The right to life from corpus of international commentary and including African human rights jurisprudence. There is the recognition that denial of essential medical care, exposure to life-threatening environmental conditions, and grossly inadequate detention healthcare may violate the right to life. So you notice that the right to life has been taken, over and above just a protection against unlawful killing, as it were, to encapsulate so many other things. That, like, remember the Ogoni case from Nigeria. This when it comes to oil, and then the destruction of the environment of the Ogoni people, or just like even like the Galamsey, you look at the which have become like the extremely brownish and so on. These are all life-threatening environmental conditions, and they definitely affect the right to health, to life, and also the right to health. And that is why Kunbour made the argument that Ghanaian courts could adopt this broader understanding of the right to life that have been emerging in the various international and African human rights case law. Another fundamental right in Chapter 5 is human dignity, Article 15. And here, the point is made that.
Please, a question.
Yes.
Sorry. So about the first one you talked about, the right to life, when you use the Nigerian oil thing, Ghana's Galamsey situation as an example. I think we spoke about this in another class where we were asking why nobody has, or a group of people have not taken the government or state to courts to ask questions about why they are denying them or denying us the right to health when it comes to the life-threatening environmental conditions posed to us in the situation. What could be done? What is the reason? Why are we not, as a people, coming together to take the state on?
Okay, so I take it as a rhetorical question. Good. So, human dignity, I think it's a rhetorical question, isn't it?
Yes, I want to know. But if the Nigerians, I mean, that oil states were able to do something of that sort that got them safety, why can't we do same?
I don't have answer until somebody decide to go to court. The courts are there. The courts don't go about looking for cases. You have to bring the case. Then when you bring the case and then you look at the reaction of the court to the case, then you begin to take it from there. So somebody must bring up the case. If the case is...
And that somebody includes her. Yeah, so I think you need to bring up the case. If you don't bring up the case, I just give you, like, for example, in when we are dealing with the medical law and ethics or healthcare law and ethics, there's this case called Elizabeth Val against Elisa Hospital about access to medical records. Not until the case was taken up, at least we didn't have any local case law which provides some insight into whether a person can demand that, as a matter of legal right, his medical records should be given to him or her. So the point I'm endeavoring to make is that there are a lot of possibilities out there, but they cannot be tested one way or the other unless and until someone takes up the matter and go to court. The courts cannot be calling for cases, no. We sit there and wait. When you bring it, you tell us you are sorry, and then we'll tell you what the authoritative position of the law is. Yeah, so if you look at Article 15 of the Constitution, it guarantees human dignity, what they call the personal.
My Lord.
Yes.
My Lord. It's in relation to the question that she asked.
Yes.
Sometimes the court proceedings take quite a time. So some people are reluctant, tell them to go to court and say, no, I'll settle the issue at home and all that.
So that's why people don't go to court. But one thing I can tell you is that um, when it comes to human rights is relatively faster than non-human rights litigation. If you look at usually human rights litigation enforcement go faster than non-human rights. So much as you may be right in saying that uh, delays could serve as a disincentive or demotivation for people to go to court. I think by and large, human rights matters are faster. And again, you haven't been to court. So mere uh, no speculation that there'll be delay, so I'll not go. I think that is even not a good argument. You have to take it up, and then you can say that, oh, this matter we took it to court is pending for 3, 5 years, and that is why we even didn't want to go to court. Then you have something to speak to. But this one is just in the realm of speculation. So you have to still do the actual thing before you can come back and make this argument. Again, Professor Tukuba in his article points out that when you have a healthcare system which humiliates patients or individuals or degrades or neglects them, it's of course undermine human dignity. And in that respect, human dignity, which is protected by Article 15 of the Constitution, is a powerful constitutional value, particularly when it comes to issues like protection of maternal health, mental health, and also detention condition. Maternal health, for example, it comes to, you go to labor wards, how pregnant women handle. Does it humiliate them? Does it degrade them? I'm sure it's only in Ghana that when people at labor, they are caned, they are lashed, or they are spanked. But when you go to other places, they will be encouraged and pampered. Yes, push on. Yes, take it easy. Like the person, but if you go to Ghana, then they will even be caning you and lashing you. True or false?
Dog.
Yes.
Nigeria is even worse.
I'm talking really. What, what, what happens then? Is it true that they subject women in labor uh, humiliating and degrading treatment in Ghana?
think it's happening anymore.
No, the question is
Sorry? I said the question is,
I said,
is it the case that women, pregnant women in labor, even if not all, some are subjected to humiliating and degrading treatment in our health facilities, including caning and spanking and all those things?
So, well, they said it used to exist. But I think in the past decade, I've not actually seen that.
Okay.
By stories that we've heard, I think they kind of shout at them and all of that. If we don't do that, you may lose the child. How can you carry this pregnancy for 9 months and because of some 30 minutes, an hour, 2 hours pain, they want to do that? Some of them do that. But then I think this contemporary midwives
Yes.
have a way they go around it. And especially the introduction of respective midwifery services. So they are taught to be more patient with them. But then sometimes I think the workload and the stress may let them go over. Yeah.
Okay. Yeah.
Senior, do you work at the labor ward? In fact, it's not happening.
I think it happens in this contemporary
Really?
Now, with the modern midwives, I know they motivate you, they encourage you, and yes, they may rate you, but they won't go to the extent of caning you. But they motivate you to push, and in that way, they may raise their voice, but they would not go to the extent of causing physical assault on you. That I don't think it happens in this era.
Okay.
But please, you can it's a matter of life and death.
I've seen this.
Please, let's one person finish. I think the lady is speaking. When she finishes, then you come. Thank you.
I think the second stage thing is a matter of life and death. So sometimes I don't think they will intentionally cane anybody. No, they don't even cane. But like my other colleague lady said, sometimes it's out of overzealousness or passion for you to bring out that baby that may push them to want to do more so that you are able to finish up. Because the very small thing you do, lives are at stake. The labor room process is not a joke. If in a second you might lose a life or lives.
So,
but to the extent of inflicting pain, I don't think that thing happens anymore.
Okay.
Even if I don't think so, it's not.
Okay, a gentleman wanted to speak. Yes. No?
My name is Charles.
Yes, Charles. Yes, Charles, let's hear you. Yeah, I think we've lost him. But based upon
slap still happens. The double slap still happens. The principle is that the moment they surprise you with a double slap and you shout like that, the baby comes out. It still happens. But caning, I've never come across and I've never seen it. They're chicks. In fact, one of them can be behind you before you realize he give you a double slap on your cheek. And as you shout like that, the baby comes out. It still happens. I put the cane but the double slap, it still happens.
so Charles, have you been to the do what the labor?
Yes, I started my practice at the district hospital.
Okay.
And as a superior there, I have an oversight of all those things. I've seen them.
Okay, right.
Specifically, the Sala West District Hospital. Upper West Regional Hospital was integrated, and we were brought there. Some of us were brought there as the foundation staff.
Okay.
So the slap is an edge for you to shout, and as you shout, you are bearing down.
No, you are already on the labor table, and this is the
as you shout, you are bearing, like you are pushing. When you shout,
the movement that is the principle. and you shout in that pain, the baby comes out.
The baby
And you see quite often.
Nobody can see them after touch out. This one is medical mechanism.
Okay, let me ask this. In view of these perceived and in some cases actual humiliation or degrading of, let's say, a pregnant woman, should we have default CS? Default in the sense that automatically you have a CS session unless you opt out to have a vaginal delivery. Should we have that?
I think now the CS option is even there. People opt for it.
No, you are saying the opt, but I'm talking about the reverse.
Taking it by default.
Yes.
An elective CS.
But the risk is higher. Generally, vaginal delivery is safer
Oh, really?
than CS. Yeah.
Oh, okay.
Everybody knows that vaginal delivery is safer.
Oh, okay.
So CS is the choice, so there's a reason. Because, I mean, you can even give anesthesia before you even do the case, the woman is dead.
Oh,
So,
wow. Okay.
things happen, so.
So CS is probably safer for the baby and more risky for the mother. And then the vaginal delivery is safer for the mother and more risky for the baby, isn't it?
Yes.
All right. Okay.
Thank you, Mama.
Okay. And I think it's also said that husbands also like CS, and then it's also protect their interest than vaginal delivery. Is that correct?
Yes.
That's not true.
The men from the CS to avoid all forms of tear or episiotomies and all that. So maybe it could be true.
It could be true. Okay.
Everything is still intact.
All right. Okay. All right. So we also have. No, but she said no. She said she never said entirely. She said it could be true.
Yeah, so that's what I'm saying. If the CS, the men are rather opposed to it. You know, when a woman undergoes CS, it will take her roughly about the action. You get it. But the episiotomy within some few distance, they'll be complaining here and all of those things.
Don't you understand, Chick?
Practical.
All right. So let's come back to law, and let's leave the Ebankomo and come back to law. Good. So we also have Article 17, the Equality and Non-Discrimination Clause. And if you look at health inequalities, they're often based upon geography in the sense of location. Look at people in the remote areas in terms of even spread of health facilities, or even sometimes when it comes to basic vaccination, immunization, and so on, they are also disadvantaged because of their location. And not only that, health personnel even don't want to accept postings there. And we know in Ghana, there was a point in time they had to introduce a policy to entice and encourage health professionals to accept posting to rural or country sites. Again, gender also contribute to health inequalities, disability, and then socioeconomic status. And all these raise constitutional concern, especially if you have like a dysfunctional national health insurance scheme like the ones that we have, where we have like a national health insurance scheme, but you go to the facility as if we are still operating the cash and carry. And now we have even like a practice where they'll tell you that, okay, there's a good medication there, but we can prescribe that for you if you want to go and buy. But if you don't want that, then they have relatively low or substandard medication, which they will just give you from the facility. Now, Dr. Kunbour makes a point that if you look at the north-side divide in Ghana, it's definitely reflect these health inequalities and implicate Article 17, which is against discrimination. There's no doubt if we look at even Ghana, like the northern part as against the southern part, it's clear. Again, if we look at the rural-urban disparities, it's also clear. And then gender, the health outcome, as we have explained. So discrimination in health is structure rather than intentional. Structure in the sense that it's based upon geography, it's based upon gender, socioeconomic factors. But if you look at the Constitution, it requires that we give attention to every aspect. And in fact, if you look at the Constitution, Article 17, with respect to anti-discrimination, you notice that the permissible discrimination does not actually include health or based upon someone's geographical location or as the case may be. The third category is the unenumerated rights. That is a right which have not been expressly been spelled out, but the foundation is provided in our Constitution. So look at Article 33 clause 5. If you look at Article 33 clause 5, there is an omnibus right, so to speak, which goes like this. The rights, duties, declaration, and guarantees relating to fundamental human rights and freedoms specifically mentioned in this chapter shall not be regarded as excluding others not specifically mentioned, which are considered to be inherent in a democracy and intended to secure the freedom and dignity of man. So, if you look at Article 33 clause 5, it's opening a big window to say that the rights which have been spelled out in Chapter 5 are not necessarily exhaustive. They are not exhaustive. In other words, these are not all the rights which Ghanaians are supposed to enjoy, but rights which have not expressly been articulated, but are considered inherent in democracy, are also part. And Dr. Kunbour makes the point that this Article 33 clause 5 provides a very strong doctrinal basis for recognizing a constitutional right to health, because health satisfies both criteria. What are the two criteria? The fact that it's inherent in democracy, because democratic participation presupposes physical and mental capacity. If you are saying that rights which are inherent in democracy are also considered to be part of the corpus of rights to be enjoyed by people in Ghana, then the argument is made that, okay, if people are to participate in democracy, they must be physically strong, they must have mental capacity. So therefore, it does not matter that if you look at the rest of Chapter 5, we don't have explicit articulation of the right to health. But to the extent that Article 33 clause 5 uh, envisages rights inherent in democracy being enjoyed by the people of Ghana. And since you cannot participate in democracy if you are not physically strong, mentally alert, then to that extent, the right to health is recognized. And two, that it secures human dignity by enabling individuals to live meaningful lives. So the other criteria, Article 3.5, is human dignity. Certainly, if we are going to protect your dignity, if you are not healthy, how can we tell you that your dignity is being upheld? You need to be healthy, as it were, and then you can live a meaningful life. Well, this attempt to use Article 33 clause 5 is a big temptation, big temptation in the sense that it can be used creatively to robe in a lot of rights which are enjoyed in other democracies but cannot be found in Ghana's constitution. But the puzzle is that even if you say that those rights are recognized under various international human rights instruments, we also have Article 75 of the Constitution, which requires parliamentary ratification. Ghana being a dualist country, the four rights and other obligations contained in international treaty could become enforceable or enjoyable in Ghana. And if that is the case, it sort of places a limitation on how far the courts can go in using Article 33 clause 5 to recruit or bring in other rights that have not been explicitly enumerated in Chapter 5, but are considered inherent in democracy or as promoting human dignity. Because if you are not careful and you decide to deploy the full creative capacity of Article 33 clause 5, you may end up undermining Article 75, which says that if Ghana has signed up like a treaty on international convention and so on, Parliament must ratify it. Parliament must pass resolution or must be domesticated in our local legislation. So that point also came up in the Siba case, as NPP against the Attorney General. Now, beyond the Constitution, he also takes a look at a statutory framework, and he points to the Public Health Act of 2012 at 851 as an important basis of trying to locate the right to health in Ghana. So if you look at the patient charter in the C schedule, for example, it articulates rights pertaining to access to quality health care, regardless of location, informed consent and information about treatment, confidentiality and privacy, non-discrimination, and then respect for patient dignity. Now, this notwithstanding, Dr. Kunbour in his article point out some significant weaknesses with respect to the Patient Charter under the Public Health Act. And he makes the point that the Act does not clearly specify enforcement mechanisms or remedies for breach. And to that extent, he is worried that the legal status of the Charter remains uncertain, particularly with respect to justiciability or enforceability. Well, he makes that point, but I don't think it is a very important weakness or is a significant criticism of the Patient Charter per Section 167. The reason being that once a statute has made a provision, you can always go to court and the remedies, whether declaratory release or you want some damages, that can always be canvassed or can be pursued without an explicit statutory provision saying that where these provisions, for example, relating to Patient Charter, are not adhered to, you need to do X, Y, Z. Again, he points to the National Health Insurance Act 2012, Act 852, and you know it already. And the National Health Insurance, Professor Kuba, especially in his article, that the National Health Insurance scheme we have is a political compromise between market-based healthcare and rights-based access. As you will notice, going back to the cash and carry policy days, you have to pay before you are treated, or you are treated and you are paid, and so on. That used to be the order of the day. And then some exemptions were made for certain category of persons. I think very old people, and also later on, I think pregnant women, children, and so on. Until post-2000, we came to have a more or less universal national health insurance scheme. And that is why he said there is a compromise between a market-based healthcare and then the rights-based access. And despite the seeming expansion in coverage, certain problems still remain. Unequal geographical access, delays in reimbursement. I'm sure if I'm to ask practitioners to have a lot to say about delays in reimbursement, when you submit your claims, I'm sure sometimes it takes more than 6 months or 3 months before the National Insurance Authority will pay you. Is that the case?
My lord, please, lately it's better. It takes about a month and they pay.
Oh,
so
that's
it's
good.
not as bad. Yes.
Oh, that's good.
And I also learned it on first come first served basis as to when we submit the claims. So when they are doing the payments, if A submitted before B, they do the payment for A before B is also paid. So
I think as for that one, I think it's fair. Because let's say that if you submitted your claim before me, it will not be fair if they jump me over you, isn't it? Or what do you think?
yes.
Yeah.
Yes.
Mm. Then we also have quality disparities. Despite the fact that we say we are on the national health insurance, you want to find out if it comes, let's say, treatment of a particular condition, let's say malaria. will it be the same quality at the Red Hospital compared to Germany, a health post or Salaga Clinic? Will it be the same under the National Health Insurance Scheme? I think, yeah.
My lord, please, no, it won't be. At Salaga or Germany, there may be health centers or a clinic manned by a medical officer. And for those clinics, they are not allowed to admit. So you can make the diagnosis of severe malaria, but you'd have to refer to a higher facility. However, Ridge Hospital can manage those cases, so they will get like full compensation for that. And if by any chance Germany or Salaga decides to treat the person, health insurance will not reimburse.
See, look at this. So those are some of the practical challenges which we are talking about, and these challenges actually bring out the gap between formal entitlement and lived reality. In other words, what is written in the law does not translate into what one receives in reality. So that is the real challenge. And of course, we also have the Mental Health Act. Because we are doing mental health law, we will not belabor the point. And the point to note in brief is that the Mental Health Act introduced a right-based paradigm, and there's so much emphasis on concern, dignity, and community-based care. And for that matter, Dr. Kunbour makes the point that mental health is an integral component of the right to health, not an optional add-on. And if we look at even the legislative response through the Mental Health Act, I think it validates that particular observation. So because you are doing that, as because all that you've learned over there, mutatis mutandis, or the necessary modification, applicable to what we are discussing. Another aspect of the right to health through statutory regime in Ghana is regulation of the health professionals. We have the Health Professional and Regulatory Bodies Act, and if you are talking about the right to health, it's also relevant. Why is it so? Now that legislation establishes regulatory framework with respect to professional competence and accountability. So the obligation of the state to protect the right to health also include regulating those deliver healthcare, as well as private actors whose conduct directly affect health outcomes. So having health professional regulatory legal regime is an aspect of the state trying to live up to its right to health obligations. So just imagine we didn't have the Medical and Dental Council, there's the Midwifery Council, Pharmacy Council, Allied the Health Professional Council, and so on and so forth. And just people could do anything at all. That will definitely undermine everything we are calling healthcare, and for that matter, the right to health. So that is the point we are trying to make. Now, what has been the situation with respect to judicial appreciation of the right to health in Ghana? Well, generally speaking, the socioeconomic rights conundrum is also acknowledged by courts because they have implication for resources. The courts have not been elected to determine how much of Ghana's money should be spent on health as opposed to housing, to be spent on road as opposed to this. So right now, for example, the government is trying to do certain major roads. So the government has been elected and they have like the political legitimacy to decide how, where, and when to uh, you know, utilize or allocate the state resources. And it's not for the courts to do that. Of course, issues of separation of powers, and then the budgetary competence and political questions, they all affect how the court reason about these matters. And for that matter, Dr. Kunbour would show a concern that that is not good. In his view, because the courts are very ready and eager to adjudicate civil and political rights, such as the right to free speech, freedom of expression, and so on, the right not to be personal liberty and all that. In his view, these rights also require some substantial public expenditure, particularly when it comes to fair trial rights and electoral processes. Elections are very expensive. So if we are prepared to spend so much resources on election, why is it that we begin to cry more when it comes to allocating resources to healthcare and other socioeconomic rights? Remember how Ghana, an MP can die or whatever reason, an MP is no longer an MP, and within the constitutional stipulated period, by-election will quickly be organized. And if you try to find out the amount of money which is used by the Electoral Commission and then the state security apparatus in prosecuting that by-election, you begin to ask, couldn't similar resources have been channeled into something of healthcare? And that is why Kunbour is trying to make the argument that this resource argument, which is often used to try and relegate socioeconomic right, including the right to health, to the background, and rather elevate civil and political rights, is really not tenable. So far as some civil and political rights also even involve significant resources outlay, just like the by-election example that I'm giving to you. So therefore, health rights should not be excluded on resources grounds alone. Well, if you look at the African Commission on Human and People's Rights under the African Charter, we cited the case of Sirac against Nigeria, and then the case of Pirot against the Gambia. You can just download all this, go to the website of African Court of Human Rights, and then click on the link on the commission. The decisions are there, you can just read them. And these decisions actually establish that the right to health is enforceable and imposes concrete obligation on states. So Dr. Kunbour invites Ghanaian courts to actually draw upon the jurisprudence or the case law from the African Courts of Human and People's Africa Commission on Human Rights. So we have already noted that there is a direct nexus between health and development policy, as Ramona Tukuba underscored in the article that we earlier mentioned. And if you also look at the our national health policies, undoubtedly, it explicitly draw a link between health outcomes on one hand and then the economic growth and human development on the other hand. So therefore, indicators such as life expectancy. So what is the life expectancy currently in Ghana? Yes. Yes.
Please, I have a question.
Yes, please go ahead. Please go ahead and let's hear you. Yeah, yeah, let's hear you. Go ahead. Please go ahead. I've lost him.
Okay. No, please, I have a on the economic right.
Yes, go ahead.
No, I've seen something. Yes, I've observed something in Ghana. I don't know. Corrected. I don't know, but it looks like a convention. Like for instance, nurses in Ghana, anytime they are going on their rotation, let me say they are so-called national. You will realize that if you look at the right to economic right, and then you look at the situation of the nurses when they are going on their rotation, in most cases, they work like a whole year before their salary or like say the token they are supposed to take, they get it. So looking at that and right to the economic right, or is that how it's supposed to be? I don't know if there's a policy that is here before they get their pay, but it's like that is what is currently happening. And I think recently this year, it resulted into a situation that one of them, out of anger, and he even publicly insulted government officials, and it led to a whole lot of stories in the media. I don't know, but is that how it's supposed to be?
Okay, I'll invite your I invite your classmates to comment on this. I don't have an answer. So anybody, is that how it's supposed to be?
So no, this is Richard. So I think that practice is not supposed to be so. But I'm sure it's because of lack of funds that makes the, if you like, the internship or the rotation allowance delay. So it comes in an accumulated fashion after they are done, maybe several months after they are done. So it was supposed to be part of the training. So initially there was nothing like patient allowance. It was supposed to be part of your salary you will take by to come in an accumulated fashion. Then they said no, the rotation or internship period is part of the training. So you are supposed to be allowance. And so it is supposed to be coming month. Then because they truncated the student allowance, they were not able to transition it. So it resulted into the back pay kind of the backlog so that it will come after you have finished. So that is the best I know about it. But I think it is not right for people to move from their places of abode to other locations to be going to, if you like, for internship or rotation on empty stomach until such a time that government makes money available. Then I think the best bet should be that whenever government has money, then they start. If government doesn't have, then they wait so that we'll be able to cure this delay and all those kind of things. Thank you.
Right. Thank you very much. I asked the question, what is the current life expectancy in the country? And so if you look at the national health policy, 65.
65 years.
65, thereabout.
Okay, good. So if you look at the national health policies, to often be pointing to life expectancy, maternal mortality, to make the point that there has been improvement in health in the country. That may be true, but the progress is not even. For some people, yes, that is true, but for greater majority of the population, that is not true. And that is why Tukuba, if you read this article, he will situate the health right within Ghana's political economy, particularly the fact that we depend upon donor support, donor influence. And now, with the US, for example, when Donald Trump came into power, the withdrawal or the closure of the USAID and how significant resource support for healthcare has been affected. And again, physical constraints. You go to IMF and other lending international organizations that impose restrictions on you. You have to reduce your budget. So somebody has a question. Nurses are not paid, your health workers are not paid, and so on. Or this segment of workers are not paid. Sometimes it's not so much the doing of the government of the day, but it has to do with the what do you call the conditionalities or restrictions which have been attached to maybe a certain facility or loan which they have gone for. And all these impact on the right to health. But all said, a point is made, and made quite poignantly by Tukuba, that it's not enough for the Constitution to provide, whether direct or indirect, articulation of health rights. More importantly, there's a need for political commitment and also equitable resource allocation. So, what we've been discussing so far, several points emerge. One, the fact that our Constitution implicitly recognizes health as a right-based value, as we can see. Two, the legal framework is fragmented, and not so much reflections have been given to it, as we can see. Scattered, legislation and even scattered provisions of the Constitution. Again, the courts, the judiciary possesses the necessary tools, the doctrinal tools, to develop health right jurisprudence, if for nothing at all. We have mentioned Article 33, Clause 5, and we don't see people picking up the trouble. Now, not until you go to court in the test cases and other things, you don't get judicial decisions. No court. I have a lot of observations about Ghanaian society. If I were a lawyer, I would probably be taking them up, even for just the good of society if there's no money. But I'm not a lawyer. I'm not an ordinary citizen. I cannot just take up the case. The case must come to court. So if cases don't come to court, the courts cannot do anything. So that is the point. And again, the other challenge we have is that our problem is not so much about not having a clear conceptual position on health rights, but it has to do with implementation. Implementation is a problem. We have a lot of good laws, good statutory frameworks, but the implementation is a problem. Yeah, so that is it. And we will draw the curtain down here. If you have any question, we will deal with them. Okay, have a good night.
Hello, my lord. My lord, I have a question.
Yeah.
Please, it comes from Dr. Benjamin Kunbour's article. On page 4, he highlights the principle that the decisions of the Supreme Court remain inconclusive as to whether the directive principle of state policy are justiciable for that matter, the rights therein. And so my concern is, I thought that it's a settled position now that it is presumptively justiciable, but he stated it's still inconclusive.
Yeah, so, well, yeah. So when he makes that point, just as you have rightly pointed out, that we say that presumptively justiciable, meaning that being part of the Constitution, there's a presumption that it's supposed to be enforced. And then the court, if you read like the Lotto case, okay, if you read like the National Lotteries case, then the point will be made that if you can get a corresponding right outside the Chapter 6, which has a bearing on a particular directive state principle in Chapter 6, then what it means is that that particular principle in Chapter 6, which has got something like a twin or a sibling or relative, as it were, in other parts of the Constitution, is supposed to be justiciable, instead of using the automatic non-justiciability argument. So that is what the court seems to be saying, that yes, it is wrong to automatically say that because if the directive principle state policy, they are not justiciable. No. We have to look at the particular one which you are seeking to enforce. I think that is my understanding of the current position.
Thank you, my lord. Thank you.
Any other? Okay, have a good night.